question, I'm going to try to segmentize and then answer these in such a way so every H-1B employer or company can understand the nuances of the DOL audit. DOL audit normally originates from a complaint by the disgruntled employee in the US or some bad reputation of the employer in the US or some of his employee going to consular processing and a consular officer finding this company has been paying low wages. The W-2 is too low, or there are some violations which the officer thinks the DOL should investigate. So these are the ways your company can be audited by the Wage and Hour Division of the U.S. Department of Labor. It is not a State Department of Labor. Keep in mind. So this program, H-1B program, comes under the U.S. DOL, Wage and Hour Division. They monitor whether the workers' rights are protected or the terms and conditions set forth in the labor condition application has been fulfilled. So their job is enforcing the law. So let's see. Somehow complaint went in and then you got a letter from the DOL. They would like to come and do the audit of the company. So don't panic yet. If you don't have public access file or you are all over the place, you can ask for extension for maybe a week or 10 days. You can hire a competent attorney, very knowledgeable in this area, and they will also assist you in getting the extension and also prepare you to deal with the DOL officers during the investigation. So you get the time now for all of the employees for last 3 to 5 years. You first prepare a spreadsheet. The spreadsheet must have employee name, job site, address, date of arrival in the US, LCA salary, W-2 wage or recent pay stub amount, and whether you file amended petition or not. So list down all of these prongs. And then if there is any discrepancy between the job site addresses of the original H-1B and the current job site, and also if there is a discrepancy between the LCA wage which was stated in and the W-2 wage. Do this math first. You will find out all of your problems by filling out and preparing this spreadsheet of the DOL investigation. And when you do this exercise, you're going to see all of your weaknesses. You don't have a public access file. Public access file has not been signed. The amendment was not filed. The proper salary wasn't paid. All of these issues are going to come. Now, also list there whether the LCA was posted at the end client site, whether you complied with the posting requirement. So that is a killer. For the posting requirement, it could be up to $2,500, $3,000 to DOL can charge you up to $35,000 for violation. So that's a lot of money you're talking about. So because of these critical issues, you must do this internal audit of your H-1B program on ongoing basis. I would recommend every year. So at least you can damage control. If there are fallout or weaknesses or violations, you can internally rectify and do not commit any fraud, but at the same time, you want to rectify the errors. You didn't pay the back wages, you pay. You didn't post the notice, you post again. So if you prepare the company in this manner to comply with the DOL regulations of the LCA, when the audit comes in, you are safe. You would not have to pay too much money towards damages, or you will not be debarred from participating with the H-1B, L-1, or even filing the labor certification or I-140. So keep that in mind. DOL investigation seems very easy, but it could have a ramification really big against your interest. So do not take it as a small work or a small piece of task. it could have a very big effect in your company's well-being. So my advice to you is, if you get the letter, take time, collect the documentation, do the exercise, make sure the posting rule is complied. Every LCA, particularly people who are going to the end client site, the end client needs to provide a confirmation stating the fact that they complied and they posted the LCA in their job site. If you don't have that, that is a big violation which could lead into debarment. Debarment could be up to 3 years. Okay, so you might have to, if the DOL decides that, and if you think it's not fair, you can go to the ALJ, Administrative Law Judge, appeal the case. You don't like that, you can go to ARB, and then you can even go all the way to the federal court. So these are the avenues to fight this case, but you got to make sure all T's are crossed and I's are dotted in relation to the compliance of various regulations originating from 20 CFR 656, which is related with the LCA compliance. Good luck.